Good evening, I'm Pinky Webb. Tonight we ask the questions, we tackle the issues, we clarify matters, and we get on point. All eyes are on the Senate impeachment court as the trial of Vice President Sara Duterte begins. More than a political exercise, the proceedings put a spotlight on the constitutional processes designed to uphold accountability in public office. What legal standards should govern the trial? Let's get on point with one of the framers of the 1987 Constitution, retired Supreme Court Senior Associate Justice Adolfo Azcuna. Justice Azcuna, again, always a pleasure to see you. Maraming salamat po sa inyong oras. Did you watch the 3 days of the trial, sir?
Yes, I did.
How did you find it?
So far, it's good. Yeah, I think it's following the constitutional directives on how it should be conducted.
You didn't see any infractions or motions that should have been allowed or disallowed?
No, it's probably just a few items, like the way the Senate President is sitting together with the presiding officer. Normally, in parliamentary practice, the chair yields to another member and doesn't have to sit beside him. But that's a preference, personal preference, I think.
What exactly do you mean by that? Are you saying, Justice, that it should just be the presiding officer sitting at the rostrum?
Yes, I think it shows that there is indecisiveness on the part of the Senate President in staying halfway between delegating the chair to another and yet at the same time appearing to be in control. So that is not something to me that looks good. It's okay for one designated to preside as long as normally the way it should be done. The Senate President opens it and then he says, I ask Senator so-and-so to chair this meeting. And then he yields. And then he's the one who closes it. So that, because he is the one really who is the normal presiding officer. Doesn't have to sit beside him, but he should be the one to open and to close. But that is parliamentary practice and it's not compulsory.
Justice, how is it like watching someone like yourself? I've always wondered about it, a senior justice of the Supreme Court, watching on television, the lawyers from both sides manifesting, stating their grounds, the articles of impeachment. When you were watching them, what were you thinking of? Were there points that you were saying, this attorney should have done this or that attorney should have done that?
Personally, I feel very fulfilled because it shows that what we have framed is being implemented and followed faithfully. So I'm very pleased with the proceedings as a realization of our framework for accountability.
You said being followed faithfully. Is that what you said,
faithfully,
sir?
So far, I think.
When you say being followed faithfully, does that necessarily mean that Chief Escudero sitting as presiding officer is above board, is legal and above board?
I think so. It is allowed under the provisions of the Constitution because we say that when it comes to the President, the one presiding should be the Chief Justice. But we are not providing for who should preside in other cases of impeachment. Instead, we just said that the Senate can adopt rules to effectively implement the provisions of the Constitution on impeachment. So, and that is what it has done. So there's no prescription on who should preside among the senators in impeachment proceedings in the Constitution.
What about what was brought up rather regarding the minutes of the meeting during the
exchange between Monsod and Davide. Davide wanted to insert an amendment stating that in all other cases, the Senate President shall preside. And Mr. Monson said, kailangan pa ba natin ilagay yan? Do we have to put that? And then because of that remark, Commissioner Davide said, I withdraw my proposal to insert this amendment. That does not mean that the proposed amendment was passed by implication because it was not even discussed. If it was presented, it could have been amended itself. I would have stood up and said, provided, however, that the Senate can make exceptions because that is the parliamentary practice. So all it means is that the Commission decided to leave it to the Senate to decide because it's an internal matter. Unlike when the Chief Justice should preside, you cannot leave that to the Senate. The Senate cannot provide for that because it cannot compel someone from another department to preside. Whereas among themselves, they can say whoever can preside. There's no need for the Constitution to say that.
Justice, how many were the members of the 1987 Constitutional Commission?
We were supposed to be 50, but only 48 accepted and participated in the proceedings.
Just wanted to find out, would that mean that the 48 that participated would have been one in saying that, for example, I'll just lay down the premise of the Chief Justice Davide, right?
Yes.
Who wanted to insert that amendment that the President shall preside over all others except the President during impeachment proceedings. Why was it not taken up so that there would have been clarity whether it should be the Senate President, as was being discussed during the minutes of the meeting of the 1987 Constitution, as compared to just basically saying it's up to the Senate, because it does say also the Senate can promulgate its own rules. Nagkakaroon ho kasi ng basehan for some senators to say it was wrong for Senator Chis Escudero to preside as presiding officer.
Yes. You see, it's difficult enough to interpret what was said in the Constitutional Commission. It is more difficult to interpret what was not said. That's even harder. So I think we should read on the basis of what is said in the Constitution, not necessarily in the deliberation. And in the Constitution, it says if the President is the one being tried, the Chief Justice should preside. Then it's silent on the other cases. Instead, it says the Senate shall adopt its own rules in order to effectively implement the provisions of this section. So you combine that, and that means the Senate can, by its rules, decide who should preside in case of impeachment.
So when you were watching that particular argument about the discussion, the minutes of the meeting, regarding the Senate President sitting as presiding officer, you were already saying that those saying that were wrong.
When I was watching that particular reference, I remember the time when Senate, in our own deliberations, when our President, Cecilia Munoz Palma, asked me to preside at the Constitutional Commission, and I did. And she would do that from time to time. It is an inherent right of the President to ask another member to preside at any given time. There's no need for the rules to say that. That's parliamentary practice. So I was thinking of that. There's no need to tell the Senate who should preside. They can decide that for themselves, unless you say the Chief Justice should preside. The Senate cannot say that. It has to be in the Constitution. But other than that, if it's among themselves, that's what Mr. Monson said, kailangan pa ba sabihin yun? That is a prerogative of the Senate.
In simple terms, Justice, because it was not explicitly written, but it was explicitly written in the Constitution that the Senate shall promulgate its own rules. That means to say that hindi po sinabi ng framers of the 1987 Constitution na dapat Senate President ang uupo bilang presiding officer, Vice President, and others.
Yes.
Okay, all right. So that's clear. Now I want to ask you about Senator Chis Escudero as presiding officer. How's he doing so far?
To my mind, he's doing very well. Those are very difficult incidents that he navigated very well. So far, I would say I would give them high grades.
What about the lawyers from both sides?
The lawyers on both sides are also doing very well. I think on round one, prosecution wins it by a slight margin. But they're both doing well for their causes.
If we were just to kind of like review, or you would review the high points of the prosecution versus the defense, can you tell us what were the strongest points from both sides?
Well, I think first is the choice of the first ground on the part of the prosecution. I think that was correct choice because the threat against the president and the first lady and the former speaker is the most easiest to understand among the charges and the articles for the people to be able to follow and understand the ground of the charge. So it's easy to understand, easy to prove because it came from the respondent herself. So what is difficult is the mens rea or the criminal intent, which is an essential element of the crime of grave threats. And it is not presumed, it has to be proven from the surrounding circumstances that it is a serious threat and that the person making it is capable of carrying it out.
Interesting you say that. Does that now come into consideration what is always or often been discussed, that the threat was conditional? Because if you talk about, sabi niyo po kailangan may criminal intent. Tama ho, Justice?
Yes.
So sa Tagalog po, pag ibig sabihin, kailangan may criminal intent, kailangan meron siya talagang planong gawin. Tama ho ba?
Merong masamang plano.
Opo.
Opo. Dalawa kasi itong krimen na ito, ang basihan ay ang Revised Penal Code. Lahat ng crimes sa Revised Penal Code kailangan ng criminal intent. Hindi pwedeng physical act lamang. Unlike kung special law, physical act is sufficient to constitute the crime. Halimbawa, illegal possession of firearms. The moment you have firearms and you have no license, guilty ka na. Whether or not you had intention to possess it is immaterial. Criminal intent is immaterial in a special law. But in the Revised Penal Code, criminal intent is essential. So grave threats is a Revised Penal Code. You have to prove not only that the threat was made, but that it was made with criminal intent.
And how do you
prove that?
How do you consider what you've seen so far? Because do you agree that there is grave threat, number one, and do you agree that there is criminal intent?
I would say, I would frame that the prosecution succeeded, I think, in proving criminal intent when the witness was asked by Senator Alan Peter Cayetano, what was your basis for assessing the seriousness of the threat? And the NBI agent said, our basis, sir, is the capability of the person making the threat to carry it out. Capability.
May kapasidad.
Ang kapasidad, kakayahan. Kaya niyang gawin yun. Kasi kung hindi niya kaya, parang biro lang yun. At kayang-kaya niya yun gawin. So talagang nakakatakot. So serious.
So because one is capable or has the capacity to do that.
Yes, that's one of the elements that go into the assessment of whether or not there is criminal intent. And I think that was a very good answer, very good point. And it's honest. I think they really do that. And that is a smart thing to do. Because, you know, when you are playing chess, you're examining the position of your opponent you do not judge the opponent based on what you think his intention is. You base it on what he can do based on the position. What is his capability? And you have to frame your moves based on his capability, not on your interpretation of his intention. Because intention is shown by capability.
We'll be taking a very short break. We'll continue our discussion with the retired Supreme Court Associate Justice Adolfo Azcuna. When we return, stay tuned. This is On Point. Welcome back. With us, retired Supreme Court Associate Justice Adolfo Azcuna. I'm going to ask the same question I asked during the break, Justice, so that the viewers can hear what you said about this as well. The mere fact that the president did not file a complaint on the allegation of grave threats now being discussed as the fourth article of impeachment in the past couple of days, does that weaken the prosecution's case?
Okay, one of the things to gauge whether or not the threat is serious is how the persons threatened reacted to it. Did they take it seriously? The fact that the President, First Lady, did not file a complaint personally does not mean they did not take it seriously. That doesn't mean that they didn't feel threatened, because they have their officials who have already, in fact, anticipated their moves and filed the complaint themselves. So this is, of course, something you have to also consider the fact that the overall situation must be taken into consideration to judge whether there was serious criminal intent. But I think not filing themselves personally is not an indication that the persons threatened did not take it seriously.
Justice, there's a petition before the Supreme Court on a number of bases to stop the impeachment proceeding. One of the bases is the election of Chis Escudero as presiding officer, which we already discussed.
Yes.
Again, you were saying that is above board, but we were showing also some graphics a while ago. I'm not sure if it came out. Again, it talks about the Senate shall promulgate its own rules, etc. And of course, also the minutes of the meeting, which you already clarified a while ago. Another point that they raised is the quorum of 12 last July, was it July 3, where we saw Senator Chis Escudero enter the plenary, was in very simple terms, basically, it was out of order because a quorum is supposed to be 13 and not 12. What do you say to that, Justice?
As I said, it is the inherent power of this presiding officer to delegate the chair to any person. There's no need for a vote, in fact. The fact that they went through the process of voting or some kind of consensus is just an additional factor. But the Senate President can, in parliamentary practice, yield or request another senator to preside at any given time.
Justice, should the Supreme Court decide on this particular petition to stop the proceedings?
It's not easy to predict what the court will decide, but personally, I think so far there is no urgency for the court to intervene, especially because this is the second time that the respondent is impeached, and the first time they did intervene. So they might be reluctant to intervene right away in view of the relatively minor complaints so far, who is to preside or not. This does not really affect the due process, so they might let it go.
16 senators to convict. There was already a decision
16.
that you need 16 to convict the Vice President. What is your take on that?
The 16 is based on 24 as members of the Senate at the present time. There are two views. The first view is it has to be based on 24 all the time because the Constitution says 2/3 of all the members of the Senate, and the Constitution says the Senate shall be composed of 24 members. I subscribe to the view that it means all the members at that present time, actual members. So if there's one vacancy, base it on 23. But right now, there is no vacancy. There's a full composition of 24 senators. So the 2/3 would be 16, regardless of whether or not the others are able to attend because they are hiding or under detention. They are still senators and therefore part of the computation of the 2/3 voting threshold.
So you still believe it's 16?
16 pa rin.
Whether or not, as you mentioned a while ago, Senator Bato de la Rosa is hiding, Senator Jinggoy Estrada is in jail, and Senator Rodante Marcoleta as well. Now, the next question would be, should they be allowed to
vote.
to attend and vote? I attend, of course, via Zoom or other social media platforms. And should they be allowed to vote? Of course, I'm not talking about Senator Bato de la... Isa-isahin na po natin siguro. Senator Bato, he's in hiding.
He's hiding. He is not being prohibited from attending. So it's up to him if he wants to attend at the risk of being arrested. With the others under detention, they can perhaps be allowed through a request of the Senate for the time that there is a hearing to be allowed to physically attend under guard. So it is a matter for the Senate and the prison authorities to decide. There could be criticism that they are given special treatment, but I think it could be justified because of the primary objective of obtaining accountability from a high official. So it's up to the Senate and the prison officials to decide whether or not to allow such an arrangement. But it should be done from the beginning because the persons who voting should be there from the start so that they are participants in the presentation of the evidence from the start.
Is it fair for me to basically understand that, sabi niyo po, it's 16, whether one is hiding, two are in jail, and you would favor, would that be the correct word, favor, the two senators presently being detained to somehow attend the proceedings?
I think somehow attend can mean physically attend or by online. Right now, the rules, I understand, requires physical presence in order to participate. However, that can be changed, and they could allow electronic attendance, participation. Although that has also its disadvantages because some of the evidence need physical appreciation, including the demeanor of witnesses. So I think the present rule is correct. Physical presence should be required as much as possible because of the need to appreciate the evidence correctly.
There is, sa last question, of course, there's that possibility, Justice, that that number 16, that magic number of 16 may be questioned before, again, the Supreme Court. It seems that a lot of motions or petitions have already been filed before the Supreme Court. Do you think that that would be the proper, not just a proper way to address it, but also to be able to once and for all understand what is 2/3 of all members or 2/3 of participating members, whatever that number will be, so that once and for all we have a number that is easily calculated?
The citizens jury, which is a forum that is following these proceedings, so is of the opinion, and I agree with it, I'm part of that citizens jury, that it is at this time ripe already for a question to be raised in the Supreme Court on this voting threshold because the presiding officer declared that as far as his interpretation is concerned, it is 16 votes needed to convict. So there's been a declaration. It is, I think there's an actual case and controversy that is ripe for judicial interpretation. At this point, that is one issue that may be brought to the Supreme Court for the judicial final determination of what it really means, this 2/3 voting threshold. But without that, we have to follow what Senator Chis Escudero said, because that's the interpretation of the presiding officer. But that is his own personal interpretation, and the Senate itself, in the end, has to be the one to decide what is their voting threshold, subject, of course, to intervention by the Supreme Court.
Apologies, there's a quick follow-up that I just thought of. When you were drafting the 1987 Constitution, and when you were thinking of 24 members of the Senate and 2/3 of all the members, did anyone ever at any point raise the possibility that what if 1, 2, or 3 members of the 24 members of the Senate might not be able to participate in any of the impeachment proceedings? Did that even come to mind back then?
I think it did not expressly come about, but you will note that in the voting in the Supreme Court itself, in our provision, we said that in order to declare a law unconstitutional, it needs the majority vote of all the members participating and voting.
Okay.
Nakalagay dun eh.
Participating in voting.
Participating and who voted on it. So if it was our intention to limit the 2/3 vote in the case of the threshold to convict in impeachment, to limit it to senators participating and voting, we could have said so. We know that language.
Yeah, but you didn't.
What we did not, we just said all members of the Senate.
Retired Supreme Court Associate Justice Adolfo Azcuna, maraming salamat po sa inyong oras. And I'll see you again, sir. Thank you. That's On Point. Join us again tomorrow, 7:30 p.m. here on BNC, the Billionario News Channel. I'm Pinky Webb. Thank you for watching.